Sweet the whispers in your ear whenever ember wanders near.
First one's from yesterday. So the court case for Reckless Ben has begun. And apparently, Reckless Ben had his first appearance in court, and he represented himself. This concerns me. If this is true if this is true that Reckless Ben went to court and he's representing himself, this concerns me. Because if he's going to if he's doing this out of some kind of like some kind of attitude, like I'm gonna show that the little guy can beat down the big bad corporation. If that's his rationale for it, I might have to reevaluate the guy's intelligence. But we don't know. This is what this whole video is about. Let's see what Andrew has to say about it.
Today we have an update in the Bricks and Minifigs versus Reckless Ben case, in which case Ben appears to be going lawyerless, pro se. We're going to go that today on The Legal Mindset, where we teach you to be your own judge.
Now, by the way, one thing I will point out, going pro se is not the legal death sentence you think it is. There's been a couple of high-profile streamers lately that have had court cases that went pro se lately and won, which Andrew may bring up. So just because then maybe going pro se is not, it was low tier god. Yeah, it was like a child custody thing or something, or maybe it was either child custody or it was what's the word I'm looking for? Child support, something like that. He was pro se and he won. He won his pro se case in court. So, well, understandably, it's going to make you wince to hear that he's going pro se. It's not, don't think, okay, he's guaranteed to lose now, because that may not necessarily be the case. Ben, as reckless as he has been, does seem to be a reasonably intelligent person. You know, with the videos he's made, he actually dug into state law for all of the stunts that he pulled. So he does know how to facilitate researching the law, how to go about legal processes, things like that. So it's not like, basically the crazy person that's like, I'm going to represent myself because I'm fucking nuts. He actually does seem to have a reasonably good brain in his head, and he can do research. So again, it's not the legal Harry Carey that most people might think it would be.
I'm Andrew Esquire, American attorney. So jumping right into it, we have several cases involving Bricks and Minifigs, the franchisees, Reckless Ben, the Mancells. But today we're going to focus on one of them that had a hearing today. And this particular one was in the 4th Judicial District for the Provo Justice Court. You see Utah, state of Utah. You see the case number there, 261-000-376. So it's for misdemeanors, and it came up in front of Stephen F. Schreer. Now, this was for 2 separate charges, the first of which was disorderly conduct, and we're going to get into what that means and what that entails. That's
interesting. Huh. Look at those dates. Is this actually a part of the Bricks and Minifigs thing? Because you look at the dates, it's December 10th of 2025. Ben was doing his Bricks and Minifigs things in March. This happened like 4 months prior to the events of Bricks and Minifigs. So what exactly is this about? And yeah, I was going to get to that next, is like with this criminal hearing, these are minor. Class B, Class C misdemeanors, disorderly conduct, criminal trespass. When was the stuff for the first door? That was March. The stuff for the first door occurred in March. So If I'm remembering correctly, it was March. It was like early to mid-March when he did the Salem store, if I'm remembering correctly. If you want to look up the video, like if you want to look up this first video, Atanashi, and see like if he mentions a date, where's Provo? Provo is Utah. Provo City is, I'm trying to think of where it is in relation to Salt Lake, and I'm not entirely sure. Are these Provo, Utah? So not the no, this is not the Oregon stuff. No, this case in particular is Oregon stuff. But this is just like Class C, Class B misdemeanors. Honestly, him going pro se for the misdemeanors, not so crazy. Like these are small little charges. You know, the disorderly conduct is a bullshit catch-all charge that police issue to someone when they're basically, acting like a complete fucking nutball and an idiot. They haven't actually done any serious criminal act. So the disorderly conduct is basically like a catch-all to basically go, well, we've got to charge him with something because this guy's been like doing like that shit crazy stuff right now and is causing people issues, even if he hasn't committed a battery. Yeah. Oh, okay. Perfect example. Remember what we saw with the Carmelo Anthony case, the Carmelo Anthony aftermath? There was the guy that was like, there was the one guy that was basically like chimping out in front of the guy wearing the American flag shirt. He was like in his face, jumping around and acting like a complete fucking idiot and just like yelling at him and like doing like the dance of his homeland or something. I don't know what the fuck that guy was doing. That would be considered disorderly conduct. That's he didn't touch the guy, he didn't harm the guy, but he his behavior was such as like he needed to be charged for something. And so it would have been disorderly conduct. So it's kind of like the catch-all. It's like a breach of peace. That's like disorderly conduct is kind of what people used to categorize as a breach of the peace. And so that is like, it's generally speaking, it's considered like a nothing charge, honestly. Even if he's found guilty, it's going to be like a fine. Okay? Even if he's found guilty. The trespass one, a little bit more serious because it's a Class B misdemeanor versus a Class C misdemeanor. But again, it's honestly not a big thing. The criminal trespass was not done with violence. The criminal trespass was not done like placing someone in fear of their life. Like, tangibly speaking, nobody was placed in fear of their life. So it's just like, you're annoying. I don't let you on my property, so I'm trespassing you. So it's just like he was annoying someone in a place that he was told you can't be here, and so they trespass him. Again, realistically, even if he's found guilty, it's gonna be like a fine, and that's it. That's legitimate, probably going to be it. So with these criminal cases, they're nothing big, they're nothing special, and I can honestly see why he might be looking to represent himself in this. I don't know, but Andrew will probably get into it. And so these are the dates. Okay, so these are the dates he confronted the CEO of Bricks and Minifigs. Okay, so their charges related to Bricks and Minifigs. This is the day that he confronted Nanan. Okay, so I can see why he wouldn't get hurt, why he would want to fight these pro se. Because he's got video footage of his entire interaction with Nanan. The entirety of his interaction with Nanan is recorded on video, which he can then bring up in court and probably completely obliterate the disorderly conduct criminal trespass. Absolutely the disorderly conduct, because he was not he was not like acting crazy or anything like that. So he could absolutely like obliterate the disorderly conduct by simply showing him the video footage that he took. And even the criminal trespass at the Bricks and Minifigs CEO's office, they never arrested him. At the Bricks and Minifigs corporate offices. When they told him you're criminal trespass, they left. So that may be why he's going pro se. There's also a chance he consult with a lawyer about how he should argue it. It is possible. But he can easily just bring his video footage of the entire incident to court, enter it into evidence, roll the fucking tape. and they'll be able to play for the judge, which will probably the judge probably will watch the tape and go, yeah, I see no disorderly conduct here. I see no criminal trespass here. Case dismissed. That may be the angle he's going for.
A Class C misdemeanor. The next was criminal trespassing, which is a Class B misdemeanor. Now, we'll get into what those mean in just a second, but first, this important message.
Recently, a jury ordered Meta and YouTube to pay millions for their role in
Does he
designing
qualify for
and
public
promoting
defendant?
addictive
Probably. He
platforms.
probably does
They
if he
knew
wanted
their
it.
apps could contribute to anxiety, depression, and body image issues, but did not share those risks while prioritizing profits. The recent historic verdict underscores the consequences of those decisions. If you or your child spent years growing up on social media and experienced serious mental health struggles, you should hear this. Morgan & Morgan is stepping up to hold these platforms accountable for the harm they caused. You can use the link in my description or scan the QR code to take a short quiz to see if you qualify for a case. You may be entitled to a
Quizzes.
potential
I don't want to get
recovery of
educated.
over $1,000.
I don't want to learn. I don't want to
All right,
leer.
now, what do those actual counts mean? Well, first, disorderly conduct is a very broad misdemeanor. It's something
Yes.
that, once again, in many places around the United States, if the police are really looking to get you for something, they can probably dig in under disorderly conduct and
Yes.
find something. So in this case,
Yeah. Disorderly conduct is basically the charge that the police use when you're being an asshole. You haven't actually done something substances of crime, but you're being an asshole and you're refusing to like get with the program and calm the fuck down, and you're just continuing to just be an asshole. And they'll use the catch-all disorderly conduct. Now, one keynote of distinction. If you're out, one keynote of distinction. If you are, and you better not be, because I will bonk your ass for this. If you are ever on the receiving end of a disorderly conduct charge, bearing in mind, a disorderly conduct charge does not apply if the police are the quote-unquote complaining party or victim. You cannot be charged with disorderly conduct against the police. Disorderly conduct only works if the complainant is a citizen, like a non-police officer. Police officers cannot be the recipients of disorderly conduct. That's a keynote of distinction.
under this statute, the particular statute, it can be refusing to comply with a lawful order of the police to move from a public place or an official meeting, to unknowingly create a hazardous or physically offensive condition by any act that serves no legitimate purpose. So that's very broad there, right? B,
Yeah.
intending to cause any public inconvenience, annoyance, or alarm, or recklessly create a risk of public inconvenience, annoyance, or alarm. It's very funny because one of the things when I covered Vitali in the Philippines.
Yes, the Depp family did get a disorderly. Well, the one video we watched about Officer Kitchen is they were going to be doing disorderly conduct, but they were good. But again, the plaintiff was not the police officer in that. The plaintiff was the mystery woman that was not present for the disorderly conduct in and of itself. And she would have been the plaintiff in that respect, not the police officers. The police officers were just going to be issuing the citation for disorderly conduct. Police can arrest you for disorderly conduct if you're a public intox without any other complaining witnesses. True, like the police officer can be like a complaining witness. If you're if you are drunk in public and you are causing a general annoyance for yourself, and the police officer can articulate that you as the offender are making the general populace in the area uncomfortable with your public intoxication, then yes, the police officer can be the complaining witness and basically go in front of the judge and say, Your Honor, the defendant was basically acting in this manner, intoxicated and acting this way, causing a visual disturbance of the people in the surrounding area. However, if someone is publicly intoxicated, there's no one else around except the cops, and they're just annoying the cops by this. The cops can't be the plaintiff. The cops can't be the complainant on that. You cannot disturb the peace of a police officer. That's the keynote of detention. The police officer can be the complaining witness to it. They can be a witness in the case saying, yes, Your Honor, we observed the defendant making these people in this area uncomfortable with their behavior. So we are the witness to it. But you cannot disturb the officer's peace. By the very nature of their job, you cannot disturb the officer's peace and thus have disorderly conduct against you if you disturb an officer's peace.
And Johnny Somalis, they said they didn't have, that the U.S. doesn't have any laws for annoying people or causing disruption. And no, in fact, this is indeed one, disorderly conduct in the U.S. Very, very, very common that has this as an element. Further, to engage in fighting or any violent, tumultuous, or threatening behavior, to make unreasonable noises in a public place or an official meeting, making unreasonable noises in a private place, which can be heard in a public place, or to obstruct vehicular or pedestrian traffic in a public place or an official meeting. So a lot of different qualifications here. Of course, this is a misdemeanor. This is not a felony. You're not going to lose any, rights here. There's no right to vote stripped away from you for this. Moving on, there's criminal trespass, which is a Class B misdemeanor, which is knowing that entry or presence or the unmanned aircraft, that's going to be the drone that they're flying, that the unmanned aircraft's entry or presence was unlawful, entered and remained upon the property, or caused the unmanned aircraft, the drone, to unlawfully enter and remain over the property.
Okay, I'm confused at this point. What the fuck is he talking about? Is there a part of this Bergson minifig saga that I am unaware of? What drone is he talking about? I don't recall seeing him using a drone in this way in either of the two videos. Does anybody know what he's talking about here? The only time I've seen him use a drone is like that he might have done some B-roll, and he used a drone for the conclusion of his second video when he was already in Mexico, so he was nowhere near them. Maybe it's a part 3. That's possible. We haven't seen part 3. You're right about that. You are correct. We haven't seen part 3. But here's the thing. Part 3, he's not doing a further investigation because he jumped from the end of part 2 and then he jumped into Mexico, and that's where he's been. So I don't think part 3 involves him doing further investigation. I think part 3 involves them basically trying to just levy more charges. Could also have been the footage he did use. That's possible. There could be footage that he didn't use that we don't know about that he used a drone to obtain. Absolutely possible.
As to which notice against entering was given by, number 1, personal communication to the actor by the owner or somebody with apparent authority to act for the owner. So telling them verbally, hey, you need to leave. And we did hear that several times. Also, fencing or other enclosures, obviously designed to exclude intruders. In some cases, there was fencing and enclosures. And 3, posting of signs reasonably likely to come to the attention of intruders. So criminal trespass, once again, similar to the disorderly conduct, it's going to be very easy to get this one. And this one is more of a layup. But once again, this is not a felony. This is not something you go away for 30 years or life or get get capital punishment over.
At most,
these
it
are
could be a
just
fine.
misdemeanors. Now, let's get to what actually went down during the hearing today.
All right, we have Benjamin Schneider online.
Yes, sorry for the last time you called. I think I hit the wrong button and accidentally got in a private meeting with the prosecutor, but I'm here now.
Oh, that's fine.
Oops.
All right, we're here on case.
So very good. They're allowing him to do things digitally. A lot of courthouses are still not up to date when it comes to digital and working online. So good for them to letting Ben to do things online.
That is increasing up. The amount of courts that are doing that are starting to do Zoom calls or remote call-ins for defendants is starting to increase. In fact, a couple of hilarious court cams has been one where there were 2 that I can remember where the person was supposed to be in court on a charge related to driving, as in they're not supposed to drive. They zoom in on the call and they're literally fucking driving while on the Zoom call with the judge. And the judge is like, "Are you driving right now?" And they're like, "No." And the judge just whips them 5 new ones because they're literally supposed to be in court for something related, a misdemeanor charge related to driving, and they're literally on the Zoom call driving. There's like 2 or 3 of them that I've seen that's just hilarious, where the judge is like, where the judge just looks at me and goes, you cannot be fucking serious right now. Yeah, it's like suspended license, DUI, something like I like probably one or the other or both. It's just yeah, it turns out yeah, there was one that they never suspended his license. There was another one where it was a woman, some fucking Karen, that it was for either a suspended license or a DUI. She's on with the judge. She tries to gaslight the judge, claiming, I'm in the passenger seat, Your Honor. I'm not actually driving. I'm having my driver pull over right now. And you see her get out of the, her seatbelt. The judge's like, ma'am, if you're the passenger, why is the seatbelt over your left shoulder instead of over your right shoulder where the passenger is? And she's like trying to gaslight the judge, like, no, Your Honor, I'm not driving. No, you're seeing things. I'm definitely not driving. And he just lights her the fuck up for blatantly lying like she did.
Case 261 ending 376, scheduled for a pretrial today. And are you representing yourself on this case, Mr. Schneider?
Yes.
So that's called pro se. That means he's representing himself. Now, mind you, this is for the very specific charges of trespass and disorderly conduct. This is not necessarily for the RICO case. He may plan to have an attorney there, but this is pretty big because while he may have confidence and he may be able to handle some things here, the thing for Ben, the thing Ben has to worry about is this web that ties together. And
Yes.
what I would be very concerned about is even if he felt confidence in this case for the trespassing for disorderly conduct to do that himself, he really needs a lawyer there to think about how these things are all going to tie together for him and how the results are going to play out.
Yeah, in layman's terms, a criminal conviction, even as a misdemeanor, even though these are piddly ass misdemeanors, a criminal conviction can and will inform on a connective civil litigation. So if he receives guilty verdicts in these little misdemeanor cases, when he goes to address the civil cases, the plaintiff in his civil case, particularly with like the RICO case, can basically present his guilty verdicts to the judge and say, Your Honor, this only strengthens our case that we are in the right because he was found guilty of these crimes in relation to what we are bringing up in our civil proceedings. So criminal does inform with civil cases that are connected in terms of the actions. The actions are connected, so the cases themselves will be connected. So yeah, and I agree. It's very stupid for him to be doing this pro se. I don't know why he's doing a pro se. I do not know what his rationale is for this. I do consider it stupid, but it is what it is.
Okay. Have you had a chance to speak with the prosecutor then?
Yes.
And that's where you got to be careful too. You got to be careful what you say to the prosecutor because,
Yep.
they're not always looking out for your best interest as the defendant. They might be looking to pull a fast one on you. They might be looking to take a different angle with you. So you have to be.
And leave us not forget, this is Utah. Bricks and Minifigs obviously has a hold on God knows how many legal administrations in the state of Utah. They've got the police department of American Fork in their pocket. They probably have the city council in their pocket. Who's to say that the Bricks and Minifigs does not have some kind of a working relationship with the prosecution of the Utah District Court? So that this is another reason why Ben should have had a lawyer. Bear in mind, I'm not applauding Ben for going pro se on this. Does he have that right? Yes. Can he make a go of it doing pro se? Yeah, he might be able to come out on top by going pro se. Nowhere close to being a fucking guarantee, but because of the fact that that Ben himself is already privy to the level of legal corruption that is taking place in regards to Bricks and Minifigs, you want to have an attorney, a neutral party, like something of a neutral party, to be speaking on your behalf. So that way, that if the lawyer does try to pull some bullshit, an experienced attorney will recognize that and can call it out to the judge and go, no, this don't fucking fly. And Ben can also shut the fuck up.
Be very careful.
Do you need time to do video footage?
Yes, there's, the defendant is claims that he gave some video footage to officers, and so I could look at that.
Okay. Does that work for you, Mr. Schneider?
Yes.
Okay. Where do you live, Mr. Schneider?
Los Angeles.
Okay.
So he's not in Utah.
July 6th,
Uh-huh.
11 o'clock in the morning. Does that work for you?
Yes.
So we got a date.
Okay. And you
July
understand that's
6th.
Utah time, right?
Yes.
And then, have you done your fingerprints yet?
When I went to, I got arrested and did a fingerprint there. I don't know if that transfers over.
Usually
It does
it's got to
not.
be case by case, although
Yeah, it's and you get fingerprints done for every single arrest. So there's no such thing as, oh, I got arrested for this and I got my fingerprints done. Can't you just take those fingerprints and apply to this charge? No, because number one, it's a different department. That's number one. So the arresting the department with the because this is Provo. This is not American Fork that he's receiving these charges. So no, he actually needs to go to the Provo Police Department and needs to actually be fingerprinted by the Provo Police Department, because that fingerprinting gets tied into the criminal complaint, and there is like a for lack of a better term, there's a receipt when you do the when you basically do the fingerprints. When it gets fired off through APHIS, you basically a case number is tied to that fingerprinting. So if they tried to actually say, oh well, take the fingerprints that got done by American Fork and apply them to the Provo case, well, no, because those the fingerprints that were taken then are tied to American Fork's police department case for there, not Provo's case. So every time they do the fingerprints, they actually have to. Because every time you do fingerprints, it gets tied to a case and it gets sent off to APHIS for basically documentation. And so, yeah, you can't, it doesn't work that way.
Own lawyer has a fool for a client. I mean, gosh, this is stupid. Duh.
Yeah.
it is very annoying. And some places do link these things up, but a lot of times it's case by case.
No, they don't.
But I've not done a fingerprint for this specific case. No.
Okay, yeah, the fingerprints are linked to the case, so you need to go to your local police department, get a fingerprint card, and mail that into the court, okay?
Interesting.
Old
Can you
school
get that done
fingerprint
by the
cards.
next court?
Yeah, I'm actually surprised that they're doing it that way. I shouldn't be, because you know what? Because fingerprints, and for those of you guys that don't know, like fingerprinting when you're arrested is done digitally these days. It is. The old ink pad and paper fingerprinting has not been done for a long time as a standard. The standard has become, you've probably seen it, it's like a glass platelet that you roll the fingerprints on. It's that your fingerprints are digitally scanned. Everything is done all digitally these days. The only time you do hard copy fingerprints is usually for job applications, where they're basically doing a background check on you. But I was going to say, well, that's unusual, but not really, because the LAPD does not have their systems are not linked to Utah's. It's not like they can basically plug in Utah's case number into their fingerprint system when they do the fingerprints. They've got to he's just got to get basically a hard copy fingerprint to mail it to mail that into the court, so the court can then assign the fingerprints, because it's like, I think there's like a universal, I think, fingerprint card that can be used that they'll send, that once it gets to the court can then basically assign that to the case and link it together. Doesn't it go in the FBI database? It doesn't. What you're thinking of APHIS, and what APHIS does is when police officers, or when the police departments fingerprint you during the course of arrest, what they do is not only does the current case that you're being charged for get linked to your fingerprints on the file, but at the same time they're also checking your fingerprints for any wants or warrants that are in the system. So yes, it's all in APHIS, but it's a matter of, like, if the LAPD have their own identifiers in their localized system. So if they were to fingerprint them in their localized system, and they try and send it through with those charges, it would be using the LAPD's identifier, not Provo's identifier. And there's no way that they could change their identifier in their hardware to match Provo's. So if they were to fingerprint him, it would basically say that, APHIS they'd be telling APHIS, okay, he's getting charged with this crime in LA, when that's not the case. He's being charged in Provo. So that's why they're hard coding it. and he's going to mail it to the court. And once they mail it to the court, then they can basically take those fingerprints, attach it to his probo case, and basically when they fire it through to APHIS, then the probo case number will be affiliated with those prints that are getting sent through.
Hearing?
Okay.
All right, that'll be the order then. Any questions for me, Mr. Schneider?
No.
Okay, thank you, sir.
Thank you. Is that it?
Yeah, we'll see you on July 6th.
So boom, there you go. You have it. They have it there to see him on July 6th. So in this, it literally seems very simple. There's not much controversial. We're going to have coming up this hearing on July 6th. But what is true, and turning to my judgment, what is true is Ben needs to lawyer up for the trial. While being pro se is fine at certain instances, and maybe for the very, very basics here to come in and make an initial plea, he definitely should be lawyering up at this point to fight these charges, to fight these cases that he's going to be seeing. They're very serious. It's not something to laugh about or to mock. And even if, mind you, these things might be entering into some sort of diversion, or there might be some sort of plea deal, it still helps to have someone who has experience in Utah and has experience in these specific areas. And I think Ben going pro se might end up in a weird, we could see a weird sovereign citizen-esque scenario coming out if it doesn't, for example, if it doesn't stack up the right way. And I don't want to see him, having to rebel against the whole justice system or having a grievance because perhaps he didn't understand something correctly. Having a lawyer at this point is definitely called for, and I do hope Ben gets an excellent lawyer to defend himself. But I want to know what you guys think in the comments below, and I will catch you on the next one.
Yeah, he definitely does. And according to Mindframe in the chat, he has gotten a lawyer for the criminal case. This was literally just a prelim to basically set a trial date. That's literally all this was. So, Ben didn't truly need a lawyer for this prelim where they're just establishing a trial date. And so in this case, being pro se was not detrimental to him, although hopefully he didn't really say anything to the prosecuting attorney when he actually jumped into the call with him that first time. But yeah, according to someone in the chat just said that he has lawyered up. He does have a lawyer that he's going to have representing him for the actual trial, which, thank God. Thank God. Is he still in Mexico? It sounds like he's not. It sounds like he's back in LA because in this prelim, Ben said that he is in Los Angeles, so it does look like he's back from Mexico. He's back in LA. I'm guessing that he was able to work something out where he got the warrant dropped because he said, I'm gonna do, I'm fully planning on coming to court. He basically did something to make good and indicated that yes, he will do as the court has asked and he will show up to court. There's no need for a warrant on it. And so I guess maybe he was able to get that warrant dropped, and he is currently in Los Angeles. Everything's being done remotely, so there it is. But I guess he's got a lawyer. According to a couple of people in chat, he did get a lawyer, thank God, and he'll be properly represented. I have a feeling that maybe, I have a suspicion that at least one of the charges, I think they're going to be, they might do no contest to, the criminal trespass. I think that they might actually attempt to do no contest on that one. And I do think they might try to fight the disorderly conduct. Although, again, depending on why he was charged with disorderly conduct, that will speak to that. I don't know. We'll see. Trial's on his next court date is on the 6th, which again, not necessarily a trial date. Okay, July 6th, we may not get a trial. His defense attorney may ask for discovery. So July 6th could just literally just be a continuance where his lawyer comes in, says, Your Honor, like a continuance, we're asking for discovery on what the defense has. And so don't get your hopes up that we're going to get this great trial come the 6th, because chances are we're not. Just keep that in mind.